The two words. The morning my mother's attorney called me a thief in open court, I was thinking about my orchids. Not about the $3.3 million figure the man kept repeating. Not about the judge, my mother's college friend of 30 years, who had taken the bench without disclosing a single detail of their relationship. Not about my mother, seated 3 rows back in the gallery in a navy dress she'd bought specifically for this occasion, dabbing at eyes that held no actual moisture. I was thinking about whether I'd remembered to ask my neighbor Marcus to water the Dendrobium on my kitchen windowsill. It blooms twice a year if you're careful. It had taken me 4 years to get the timing right. That's the thing about going to war with your own family. You learn to find stillness wherever you can find it, or you lose your mind entirely. My name is Delilah Osei-Mensah. I'm 38 years old. I'm a licensed estate planning attorney with 17 years of practice, a partner at Whitmore & Associates in Charlotte, North Carolina, and for the past 4 months, I had been the defendant in a civil lawsuit filed by my own mother. A lawsuit that accused me of stealing the inheritance my grandmother had left me, manipulating a vulnerable elderly woman, forging legal documents, and misappropriating assets totaling $3.3 million. Every single word of it was a lie. But that's the thing about lies told by people who know you, told by people who raised you, told by people who understand exactly which details to include to make the lie feel real. They're not easy to disprove in the time it takes a judge to form a first impression. And first impressions in a courtroom can outlast evidence. That's why my mother had arranged for this particular judge. I need to tell you about my grandmother first because without Eleanor Osei, none of what happened makes any sense. My grandmother came to the United States from Ghana in 1971 with $40, a sewing kit, and an address for a cousin in Charlotte who turned out to have moved to Detroit 2 months prior. She slept on a church pew for 11 days before finding work as a seamstress in a textile factory. By 1985 she owned 3 alterations shops. By 1995 she owned a commercial laundry operation with 14 employees. By 2010 she owned 4 pieces of commercial real estate in Mecklenburg County and a portfolio of municipal bonds she'd built slowly, carefully, over 30 years of reinvesting every dollar she didn't absolutely need. My grandmother was, by the time of her death last March, worth approximately $4.2 million. She was also the only person in my family who had ever looked at me and seen exactly who I was. I was the quiet one. The studious one. The one who didn't go to prom because I was studying for the bar exam simulation my pre-law professor had organized. My older sister Renata was the beautiful one, the social one, the one my mother introduced first at every family gathering. My younger brother Kwame was the talented one, the athlete, the one my father had coached through 3 years of high school football before his knee gave out. I was the one who read in the corner. The one whose achievements, summa cum laude from UNC Law Review, clerkship with a federal judge, partnership track at 32. My mother acknowledged with a brief nod before asking whether Renata had told me about her new condo. My grandmother saw it. She never said it directly, she wasn't that kind of woman. But she showed it in the way she called me every Sunday afternoon for 15 years. In the way she kept a framed photo of my law school graduation on her living room mantel, not tucked away in a hallway but centered on the mantel between 2 white candles. In the way she asked me in 2018 to help her update her estate plan. I referred her to a colleague. I was careful about that, meticulous, precisely because I knew my family would one day scrutinize anything I touched. I referred her to Patricia Huang at Stokes & Huang, a woman with 30 years of estate law experience and a reputation so clean it squeaked. Patricia drafted the documents. I never touched them. I was present for one conversation in which my grandmother explained her wishes, and I was present as a witness at signing, but so were 2 other witnesses, a notary and Patricia herself. My grandmother's wishes were clear. The 4 properties and the bond portfolio, totaling $3.3 million at the time of drafting, went to me. Specific bequests of cash, jewelry and personal effects went to my mother, Renata and Kwame. The remainder of her liquid accounts, approximately $900,000, was split evenly among her 3 grandchildren. My mother received $220,000 in cash, her mother's gold jewelry, and a hand-woven Kent cloth that had come from her grandmother's village in the Ashanti region. It was, by any reasonable measure, a generous bequest. It was not, by my mother's measure, enough. The lawsuit was filed 11 days after the will was admitted to probate. I found out by email, Not from my mother, not from Renata, not from Kwame, who I later learned had known for 3 weeks and said nothing. I found out because a process server appeared at my office building on a Tuesday morning and handed a sealed envelope to our receptionist, who brought it to my desk with the particular expression of someone delivering bad news they don't fully understand. I read it twice. Then I closed my office door, sat down, and did not move for approximately 4 minutes. Then I called my colleague James Whitmore, senior partner, and asked if he knew anyone excellent in civil litigation who wasn't already compromised by proximity to my family. He gave me 3 names. I called all 3 the same afternoon. By Thursday I had retained Camille Torres. Camille is 44, originally from San Antonio, built like someone who has been in courtrooms so long she has absorbed their architecture. She has a way of listening that makes you feel she is filing everything you say into a system you'll never fully access, and a way of speaking in court that is so precise it leaves opposing counsel nowhere to stand. I had seen her work twice before. Once at a continuing legal education seminar, once when she represented a client our firm had referred to her. I trusted her completely, which was significant because I do not trust easily. We met for 4 hours on Thursday evening in her conference room. I laid out everything I knew. She asked questions I hadn't expected. Then she was quiet for a long moment and said, "Delilah, I need to ask you something directly." "Ask. Is there anything at all, that your family could point to, misrepresent, or distort into evidence of undue influence? Any conversation, any phone call, any moment where you were alone with your grandmother discussing her estate?" I told her about the 2018 conversation. I told her I had referred Eleanor to Patricia Huang specifically to create distance. I told her Patricia had the complete file. Camille nodded slowly. "Good. That was smart." She paused. "You planned for this, didn't you? Before it happened." "I planned for the possibility," I said. "My grandmother left me more than she left my mother. I knew that would never be accepted quietly." He studied me. "Hey. Then let's go to work." What my family didn't know, what I had been careful to keep quiet for reasons that had nothing to do with this lawsuit and everything to do with simple peace, was the state of my professional life in the 2 years leading up to my grandmother's death. In 2021, I had been approached by the founding partners of Whitmore and Associates to lead a new division, institutional estate planning focused on high-net-worth clients, family offices, and charitable foundations. I had built that division from 6 clients to 61 in 18 months. I had structured a charitable remainder trust for a tech entrepreneur worth $340 million that was featured in a North Carolina Bar Association journal. I had been named to the Charlotte Business Journal's list of most influential lawyers under 40. I did not post this on social media. I did not bring it up at family dinners. My mother had a reliable way of receiving news of my success. A brief pause, a quick redirect, that made sharing it feel less like joy and more like offering something up to be diminished. So I stopped offering. My work was my private country. My colleagues were my real community. My friends, James, Camille before this case, my running partner Adiz who had known me since law school, my neighbor Marcus who fed my orchids when I traveled. These were my people. My family was an obligation I honored carefully and at a distance. I had also in 2022 purchased a home. A 3-bedroom Craftsman in Plaza Midwood, paid for in cash, because I had been saving since my first year of practice and because I don't carry debt I can avoid. My mother had visited once briefly and said the neighborhood was coming up, in a tone that suggested it hadn't quite arrived. The house was worth $620,000 at purchase. By the time of the lawsuit it had been appraised at $740,000. My mother's attorney would later suggest in pretrial filings that this purchase had been funded with diverted inheritance money. It had been purchased 14 months before my grandmother died. The date was on the deed. The deed was in my folder. I want to tell you about the judge because this is the part that still makes something cold move through me when I think about it. The Honorable Raymond Beaumont had been on the Mecklenburg County Civil Bench for 9 years. He was 61, silver-haired, known for his patience with self-represented litigants and his precision with evidentiary rulings. He had a good reputation. That's the difficult part. He had a genuinely good reputation, which meant that what my mother had arranged was not obvious. It looked like coincidence. It looked like a routine case assignment. I found out about their relationship 6 days before trial. I was reviewing Judge Beaumont's public financial disclosure forms, routine preparation, Something I do for any judge before I appear in their courtroom, a habit from my clerkship days. And in the 2021 form under gifts and hospitality received, was an entry. Charitable event attendance, O.C. Henderson Family Foundation Gala, value EST $350. The O.C. Henderson Family Foundation was my mother's project. A small charitable organization she'd established in 2019, ostensibly to fund scholarships for first-generation college students, functionally a social vehicle that allowed her to host events, cultivate relationships and hold court. She had raised, to date, approximately $180,000. She had distributed in actual scholarships approximately $41,000. Judge Beaumont had attended her gala. In 2021. And again in 2022. Both disclosed. Both marked as gifts of nominal value. I pulled the Foundation's public 990 filings. Raymond Beaumont was listed as a friend and supporter. There was a photograph on the Foundation's archived website. I found it through the Wayback Machine, of my mother and Judge Beaumont at the 2022 event, her hand on his arm, both of them laughing. 30 years. She'd told Renata 30 years when she thought I wasn't listening at Thanksgiving the week before trial. I had been in the kitchen. I had heard her say, "Raymond and I go back 30 years. This is going to be fine." I had said nothing. I had carried my dish to the table and sat down and listened to my family talk about a lawsuit against me as though I were not in the room, and I had thought about my orchids and I had waited. The morning of trial I arrived at the Mecklenburg County Courthouse at 7:42 a.m. Camille was already there, her second chair Marcus Webb beside her. Not my neighbor Marcus, a different one, a young associate so meticulous he color-coded his exhibit binders. Patricia Huang had agreed to testify. My grandmother's primary physician, Dr. Anselm Carter, had agreed to testify regarding Eleanor's cognitive clarity at the time of signing. I had subpoenaed my grandmother's bank records, her phone records, and 3 years of financial statements. I had also tucked into a separate manila folder in my briefcase the document I had found 6 days ago. The photograph. The 990 filings. The financial disclosure forms. A printed summary of the relationship, 1 page, clean with citations. My mother arrived at 8:15 with Renata, Kwame, and their attorney, a man named Gordon Fitch who had a television lawyer quality to his appearance. White teeth, good suit, voice calibrated for maximum authority. He nodded at Camille with practiced condescension. He did not look at me at all, which I took as information. At 9:03, Judge Raymond Beaumont took the bench. He was exactly as his photograph suggested. Authoritative, measured, silver-haired. He reviewed the docket without hurry. When he looked up, his eyes moved across the courtroom with the practiced neutrality of an experienced jurist. They lingered, almost imperceptibly, on my mother's section of the gallery. Almost. I caught it. I noted it. I said nothing. Gordon Fitch opened. He was good, I'll give him that. He told a story about a devoted daughter taken advantage of, about an elderly woman's final years colored by one granddaughter's careful manipulation, about a family's grief compounded by betrayal. He used the word vulnerable 11 times. He used the word trust 9 times. He used the phrase, as you'll hear from the evidence, with the confidence of a man who believed the evidence was already arranged in his favor. My mother cried on schedule, a single tear right cheek during the phrase in her final months. Judge Beaumont's expression remained neutral. His pen moved. Camille's opening was shorter. 12 minutes. She laid out our witnesses, our documents, our timeline. She said, "Your Honor, what the plaintiff calls misappropriation, the record calls a will. What the plaintiff calls undue influence, the record calls a 30-year relationship between a grandmother and a granddaughter. We will show you every document. We will show you the original. We will show you the timeline. And at the end of this, we will ask you to look at what this lawsuit actually is. A family's attempt to override a woman's last wishes because those wishes didn't match their expectations." Gordon Fitch objected twice during her opening. Both were overruled. After the second overrule, I watched my mother's face. Just briefly. The confidence was still there, but there was a small adjustment, a tightening around the eyes. She had expected the overrules to go the other way. I took my folder from my briefcase and set it on the table. The morning session went as expected. Fitch called his first witness, Renata. My sister is 3 years older than me and has never, in my recollection, said anything about me that was both true and kind at the same time. On the stand she was precise and tearful in turns, describing a grandmother who had been confused in her last years, and a sister who had always been angling for grandma's money. When asked whether she had ever witnessed my grandmother express uncertainty about her estate plan, Renata said without blinking, "She told me once that she felt pressured. That Delilah was always there, always steering." Camille's cross was clean and surgical. She asked Renata to identify the date of this alleged conversation. Renata couldn't. She asked whether Renata had reported this pressure to anyone. A doctor, another family member, a lawyer, at the time. She hadn't. She asked whether Renata had attended the will signing. She hadn't. She asked whether Renata was aware that the estate documents had been drafted by an independent attorney with no professional or personal relationship with me. "I didn't know that," Renata said. "You didn't know that the attorney who drafted your grandmother's will was entirely independent of your sister?" "No." "Did you ask?" Pause. "No." "So when you filed this lawsuit accusing your sister of undue influence, you hadn't verified the basic facts of how the documents were created?" Gordon Fitch objected, argumentative, sustained. But the jury, there was no jury in this civil proceeding, only the judge, had heard it. And I watched Judge Beaumont write something on his notepad. Kwame testified after the lunch recess. His testimony was shorter and vaguer. He had less to offer because he'd had less contact with our grandmother in her final years. He had been living in Atlanta building a real estate business that was, by all accounts, struggling. He needed money. This was not stated in his testimony. Didn't need to be. The subtext was plain enough. Camille's cross with Kwame was brief. She asked him one question that mattered. "Mr. Osemensa, are you currently in default on a commercial property loan in Fulton County, Georgia?" Fitch objected. Relevance. "Camille, Your Honor, the plaintiff's financial circumstances are directly relevant to motive in a contested inheritance proceeding." Judge Beaumont looked at Fitch. Then at Camille. Then briefly at me. "Overruled," he said. "The witness will answer." Kwame answered yes. He answered yes very quietly. It was at the end of the second day, during a brief recess before Fitch called his final witness. An estate expert he'd retained who I knew from his CV had never actually litigated an undue influence case, that I made my move. I had been waiting for the right moment. Not impatiently, but the way you wait for a kettle knowing it will come. I had the document in my folder. I had been carrying it for 6 days. I had discussed it with Camille every evening of the trial, measuring the moment, deciding when the impact would be cleanest. The answer was now. The recess was called. The gallery stirred. My mother stood to speak to Fitch. Judge Beaumont rose and was moving toward the door to his chambers. I leaned to Camille's ear. I said 2 words. "Judicial conduct." She turned to look at me. I watched the color leave her face, not from fear, but from the sudden precise recognition of what I was handing her. She had seen my file. She knew what was in it. She had advised me to wait, to choose the moment, to be certain. He was certain now. She stood. "Your Honor." Her voice was level and clean, and it carried to every corner of the room. Judge Beaumont stopped at the chamber door and turned. "Your Honor, we move for immediate recusal on the grounds of undisclosed personal relationship between the court and the plaintiff." The gallery went completely still. My mother, halfway out of her seat, sat back down. "Counsel." Judge Beaumont's voice was careful. "This is a serious motion." "Yes, Your Honor." "It is." Camille reached for the folder. Mine, the one I had placed on the table, the one I had carried for 6 days, and approached the bench. "We're submitting a 1-page summary with 4 supporting documents. Judge Beaumont's 2021 and 2022 financial disclosure forms showing attendance at the Plaintiff's Charitable Foundation Gala, the Foundation's 990 filings listing Your Honor as a friend and supporter, and a photograph from the Foundation's archived website showing the plaintiff and Your Honor at the 2022 event." She paused. "We're also prepared to call the plaintiff to testify as to the nature and duration of this relationship if the court requires." Judge Beaumont took the folder. He read for 30 seconds. The courtroom did not make a sound. Gordon Fitch was on his feet, but he hadn't spoken yet. He was looking at his client. My mother was looking at the judge. Her expression had passed through surprise and was now somewhere I had never seen on her face before, something close to reckoning. Judge Beaumont set the folder down. "I'm going to ask both counsel to remain," he said. His voice had changed, not in volume but in quality. The easy authority was still there, but underneath it now was something more careful. "We will recess until tomorrow morning. I will review this submission overnight. I will also be contacting the Chief Judge's office this evening." He looked up. Not at Camille. Not at Fitch. At the room. "If the relationship described in this submission is as characterized, recusal is mandatory under Canon 3 of the Code of Judicial Conduct. I want to be clear, the court takes this seriously." Another pause. "Court is in recess." He left the bench. For a moment nobody moved. Then my mother turned and looked at me. For the first time in this entire proceeding, in 4 months of lawsuit, in 38 years of being the quiet one in the corner, she looked at me without the overlay of management, without the slight tilt of condescension, without the arranged expression she wore when I was in the room. She looked at me with something raw and unprocessed. I looked back. I did not look away. I did not speak. Then I gathered my files, placed them neatly in my briefcase and walked out of the courtroom. Judge Beaumont recused himself the following morning. His written statement was brief, precise, and cost him something. You could feel it in the formality of the language, in the way a careful man acknowledged an error he believed to be technical but knew would follow him. He did not characterize his relationship with my mother as improper, but he acknowledged that the appearance of impartiality had been compromised and that reassignment was mandatory. The case was reassigned to the Honorable Constance Mbeki, who had a different quality of stillness from Judge Beaumont. Sharper, less patient, and with a reputation for making plaintiff's counsel feel the weight of bringing weak cases into her courtroom. Gordon Fitch moved for a continuance to allow time for new counsel to prepare. Judge Mbeki granted 2 weeks, not the 6 he'd asked for. During those 2 weeks, Camille and I finished building what we had already started: the complete evidentiary record. Patricia Huang's deposition. Dr. Carter's signed declaration regarding Eleanor's cognitive status. My bank records, clean and documented, showing the 2021 house purchase funded by 8 years of savings. Every wire transfer, every receipt, every date, arranged in a timeline that left no shadow. We also submitted to Judge Mbeki's court a motion for attorney's fees and sanctions based on the undisclosed judicial relationship and the fundamental weakness of the plaintiff's evidentiary case. It was aggressive. Camille warned me it might antagonize. I told her to file it. When the case reconvened, it lasted 4 hours. Judge Mbeki did not let Fitch finish his evidentiary presentation. She asked him midway through his third exhibit, a bank statement he was attempting to characterize as showing suspicious transfers, to explain why the transfers he was highlighting predated my grandmother's death by 3 years. He couldn't explain it cleanly. She asked him to explain why the independent attorney who had drafted the will had not been deposed in the 4 months since filing. He said they had been unable to reach her. Patricia Huang was in the courtroom. He had been there since 9 a.m. "Ms. Huang," Judge Mbeki said, looking directly at the gallery. "Are you present?" Patricia stood. "Yes, Your Honor." "Were you contacted by plaintiff's counsel for deposition?" "No, Your Honor." Judge Mbeki wrote something on her notepad. Fitch sat down. "Camille presented our case in 2 hours. Patricia testified to the drafting process, the safeguards, my deliberate non-involvement. Dr. Carter testified to my grandmother's cognitive clarity, not just at signing but across the 18 months prior, documented in clinical notes. I submitted the deed to my home, dated 14 months before Eleanor's death, with the purchase funded to the penny. Then Camille introduced one final piece of evidence, a letter. Handwritten, 2 pages, dated 8 months before my grandmother's death. In Eleanor's handwriting, addressed to no one in particular, discovered by Patricia Huang in the file she'd kept sealed since drafting. It wasn't a legal document. It wasn't a codicil or an amendment. It was a letter my grandmother had written to the universe, or to her own conscience, or to the daughter she'd raised who had turned her granddaughter into a footnote. I will not reproduce what it said. Some things are not for public performance. I will tell you that Judge Mbeki read it without expression, set it down and was quiet for a long moment. Then she ruled. The lawsuit was dismissed with prejudice. The plaintiff's claims were found to be without evidentiary basis. Sanctions were awarded under Rule 11. Attorney's fees and costs totaling $87,000 to be paid by the plaintiff. The court additionally referred the judicial conduct matter to the State Bar's Judicial Oversight Committee for review. Gordon Fitch did not meet my eyes when he left the courtroom. My mother stood in the gallery for a moment after the ruling. Renata touched her arm. She shook it off. Then she walked out without looking back. Kwame was not in the courtroom that day. He had been in Atlanta, I learned later, meeting with a bankruptcy attorney. I want to tell you what happened after, but I want to tell it honestly because the honest version is not clean. Camille and I had dinner that evening at a restaurant she liked in Uptown. We ordered wine and she gave a small, controlled smile and said, "You did well." That was high praise from Camille. I received it. I went home to my house in Plaza Midwood and I sat in my kitchen for a long time without turning the lights on. The orchid on the windowsill had bloomed. Marcus had watered it. 2 white flowers open in the dark. I had one. Everything that should have happened had happened. The record was clear. My grandmother's wishes were honored. The people who had tried to take what was mine had been made to account for it in the only language that had ever meant anything to them. Legal, financial, documented. And I felt something I hadn't expected. Not triumph. Not relief. Something more complicated. I had spent 6 months preparing to defend myself against my own family. 6 months carrying a folder, building a case, watching, waiting. I had been meticulous and I had been right and I had won. And my grandmother was still dead. And my mother, who had raised me, who had made me feel invisible for 38 years, had stood in a courtroom and called me a thief in front of strangers. And I had not cried. I had not broken. I had held my stillness like a professional and I had deployed my evidence at the right moment and I had been correct about everything. And I would never, not once, not under any circumstance, get to go back and have a mother who saw me clearly. That is the part that doesn't go away. The properties transferred to my name cleanly. I hired a property management company to handle the commercial leases. I retained a financial advisor for the bond portfolio. The inheritance my grandmother had built over 50 years of careful work is now in the hands of someone who will be careful with it, because she raised me to be careful in her Sunday phone calls, in the way she asked questions, in the white candles flanking my law school graduation photo on her mantle. I kept the photo. It's on my mantle now. Renata texted me 3 weeks after the ruling. The message said, "I hope you're happy." I read it twice and did not respond. There was nothing to say that was both honest and kind, and I had learned that from somewhere. Kwame called 6 weeks later, not about the lawsuit, but because he needed to know if I knew any bankruptcy attorneys in Atlanta. I gave him 2 names. He said thank you. I said you're welcome. We didn't speak about anything else. My mother has not contacted me. I don't know yet what that means for whatever remains between us. I know what it meant for the lawsuit. It meant she was cornered and she knew it and she chose silence over accountability, which is her oldest pattern. I have stopped expecting her to break it. What I have instead, my work which I am good at and which matters, a house in a neighborhood that has very much arrived, an orchid that blooms twice a year if you're careful, a neighbor who waters it when I'm away, a best friend who runs 6 miles with me every Saturday morning, colleagues who respect me, a grandmother's legacy I will steward the way it deserves. And a folder sitting in my filing cabinet at home that I will never need to open again. I keep it anyway. You keep the things that proved you were always who you said you were. You keep them not to use as weapons but because some part of you still needs to hold the evidence in your hands and remember. I knew. I prepared. I was ready. And when they came for me I was ready.